So, good afternoon, everyone. My name is Taso Pardalis, and this is PN Lawyers Back to Business webinar for 2020. A necessary toolkit for re-entering and conducting business in the remainder of this year. Thank you all for joining us today. You know, we usually do these events live, but this situation is a bit unique, and given COVID, we decided to switch the format to this webinar and get you guys the information that you need. So, you know, I can't wait to actually get back to live, and I hope we can all meet in person one day soon. I have seen Rick, one of our guests here today, on the street a few times. So that was nice, but otherwise it's been pretty lonely here in the office alone. So today we're going to cover a few topics, okay? We're going to cover the business plan, saving your space and protecting your company from any leases or contracts you may be in, employment issues in the post-COVID landscape, and protecting your brand and your intellectual property. You know, we'll then enter into a Q&A. So if you have any questions along the way, just type them into the chat on the right there, and we'll spread the questions out and answer them once this is over. So who are we? We are Pardalis and Nohavicka. We are a law firm, full service law firm, both in litigation and commercial transactions, with offices in Manhattan, Queens, Long Island, New Jersey, and WeWork. About a year or two ago, we became the only law firm offered globally on WeWork Services Store. So we actually service startups around the globe through WeWork. We started very small, about 10 years ago in Astoria, and have since built one of the best legal teams in the business. We offer full spectrum commercial legal services, from litigation to corporate transactions, contracts, business disputes, intellectual property, trademarks, employment, and just really almost everything. You know, we do most of this at a price that small and mid-sized businesses can sustain. And that's really what our business model is built on. It's built on servicing small and mid-sized businesses at pricing that they can live with, okay? You know, we very often are able to offer the type of flexibility that you don't see with law firms generally. And, you know, my partner, Joe, and I, Joe is here, we were both in business before we became attorneys, so we get it. You know, we understand business as owners, not just as lawyers. And I think that really translates to our customers. And when they deal with us and they see that, you know, it really just, it translates very well for customers. So we started hosting events similar to this about 5 years ago. They're always very well received, and the businesses in the startup community always get a lot of good legal advice out of it. You know, from the formation of your corporate entity to how to structure the company, to the financing of the company, brand protection, trademarks, contracts, employment law, and so on, right? And that's what we're going to cover today. But today I've added something that, as lawyers, we tend to gloss over a lot. I wanted to speak today about the business plan. So that's where we'll begin. So why you should have one and what it is. Every business needs one. And a good business plan, or a pitch deck, as you might hear out there, gives you a chance to really nail your company's first impression to potential investors or customers, okay? It can help you quickly sell your product, okay? And most business plans begin with a company overview, the mission statement, okay? You want to quickly, in one sentence if you can, explain what is the problem that you're solving or you're attacking and how you plan to do that, okay? An example would be Google. We are Google, okay? We are here to provide free access to information to everybody. And that's it. You can summarize it in one quick sentence. In this company overview, you want that mission statement to really hit home in one sentence. You want a summary of the company's legal structure. Is it an LLC? Is it a Delaware Corp? Is it a partnership? Is it a joint venture with another entity? You want a little brief history, you know, where the company was founded, who the founders are, okay? What is the reason that this company needs to exist, okay? Most investors and customers really believe in following a person or a team, okay? Show them who that is and why people need you. The second part of the business plan that's really important is the services that you offer, okay? It's important to define all the services. You want to give customers or investors a clear idea of what they are getting when they come to you, okay? What does your product or service achieve for them? What is the problem that your product or service solves for the customer, okay? How does your product do this? How does it solve the problem? Who is your competition? And what makes you unique in that market, okay? And going back to, you know, how does your product or your service solve the problem? Do you have a technology or intellectual property that you're using or that you're building to solve this problem? Or do you have a unique business model that, is different or better than your competitors that you can inform your potential investor or your client about, okay? And what you're going to hear a lot from investors especially is like, hey, that's a really great idea, but how are you going to make money? Or how are you going to get customers? You know, everybody has a good idea. And that's where you answer this in the plan up front, okay? You do this by one, you define your market, okay? You lay out your marketing and your sales plans. You detail the strategies that you're going to use to reach your customers. You know, investors want to know how you're going to go about generating sales, okay? You need that marketing and sales plan in the business plan. You know, determine how you're going to promote your products, okay, or your services. Are you going to promote them on social media? Are you going to do live events? Are you going to do webinars like this one? Are you going to the penny savers, right? You need to have a plan and a layout how you're going to generate sales and revenue for these people, okay? Then the next part of that is finances, okay? You want to answer or project as much as you can up front, okay? Of course, a lot of businesses don't yet have finances and are not rolling, especially for you startups out there, but you want to project as best as you can. How much does this business need to get going? Year one, year two, year three, okay? How much do you plan to raise in total? Where is that money going to get spent? So I'm asking you for $10. I plan to spend $2.50 on X, $5 on Y, okay? What is the cost of providing the service? So we're going to provide X service. This is what it's going to cost us to provide the service. And then you want to lay out the pricing for that service as simply as you can. So it will cost me $5 to sell this, and I will sell it for $8. The investor can at least get a gauge of what type of net profit to expect in this projection, okay? This portion, the finance portion, should also include due dates and milestones for this performance and for the numbers you lay out. So, you know, you can't go and ask for $1 million and not say, okay, I plan to hit X by January and Y by March, okay? You need to, with those metrics, lay out milestones for performance that the investor can see, okay? And of course, a lot of this is projected, like I said, but it's better than not having any idea and being asked, well, how do you make money? And you know, a lot of people who get into business early, they don't think, to create this or to model it up front. But it really makes it a lot easier to raise money and even to show customers where you're headed if you have these financials inside your business plan, okay? So now you've painted the picture of your financials and of the metrics and the milestones of the business. So what's next? Well, by the way, the person who's logged on here is PN Lawyers. There's a PowerPoint going in case you guys haven't seen it. So all of these bullet points that I'm going through are in the PowerPoint, and that PowerPoint and this presentation will be available afterwards, okay? So now here we are. We've created our business plan. We've laid out, the mission statement. We've laid out the financials and the projections. What's next? We've painted this beautiful picture. Management, okay? The management team who's running this show is to most investors just as important as the financials. Who is your management team? Who is on your board of directors? You need to include this in your business plan. You want to have their photographs. You want to have their bios. You want to show the investors and the customers who come to your website or look at this plan why these people are critical to the operation, why they should use you. Look at the experience we have. Look at the people who are operating this business. You need to explain why each member is the right person for the job in this specific industry. And, you know, I say this all the time to people who come in, who are looking for advice either on their business plan or on structuring the company. Investors care more about people than products or projections, okay? They care more about who is driving the product than about the product itself. Who is on your team? Are they investing in you? They're investing in you, not just in your idea, okay? So just one more final thing for me before we move on to Nataly Goldstein. Post-COVID business measures and COVID business measures, okay? So, you know, in New York, we now have the New York Forward Safety Plan required for any business, okay? Each business or business entity in New York must develop a written safety plan outlining how its workplace will prevent the spread of COVID-19. We have one here. It's actually sitting on my desk. This plan does not need to be submitted to any state agency or to the government for approval, but it must be on the premises and it must be made available because every business can be visited by the Department of Health for an inspection. And if you do not have that there, you will be fined, okay? The business plan must cover physical distancing requirements, cleaning and disinfection procedures, contact tracing, and how you communicate with your employees and clients during the COVID landscape. And you know, these are more requirements that are now imposed on businesses that are either open or reopening, but it's important that you comply with them, not just because we're required to, but they're good measures for everyone to protect the business and its employees. So it's been, you know, a bit of a rough ride with COVID for all businesses. And just in parting, I think, you know, here we've learned a few lessons. And you know, there were some big challenges and some unexpected things, but, you know, some of the takeaways from me personally here at our firm is that, you know, we were able to really build a strategy for working remotely in the event of a catastrophe, whether it's COVID or a building is burning down. You know, we've found platforms to use, whether it's Google Meet or Zoom for communication and GChat, which is what we're using to keep in touch with our team all day. We've managed to keep the lines of communication open the whole time. We're actually communicating more now that everyone's working remotely than we were when we were all sitting here together, which is amazing. You know, we've also found that, you know, we need to be way more agile than we were, and that, you know, it's important to adapt, and the earlier you can adapt, the safer you'll be. You know, we found value in collaboration, and it, you know, while times are tough, there are lessons to be taken away, and for us, those lessons were to modernize the business and to really up the communication, and it's paid off for us, and, you know, we're open, and it's been great. So that's all for me. I'm going to move on and I'm going to introduce our associate, Nataly Goldstein, who heads our real estate and transactional department. Nataly's going to talk to you guys today about saving your space and protecting yourself in this climate from contracts that you may have entered into and the performance of those. Nataly?
Thanks, Taso.
Thanks.
Now that you've formed your company and you have your idea, the ball's rolling, you might need a space to work from. I know many of you are probably working from home, but people think that now is actually the worst time to find a commercial space, but it actually might be the best time because the prices are low and landlords want to fill the spaces. So now would be an ultimate time to negotiate the terms of your lease as well as the rents that would be due. So for those who are entering into a new commercial lease, whether it's an office space, a retail space, you know, you should be aware of what you're getting yourself into and educate yourself with the terms of the lease and what possibilities you have if this persists or if your business fails. And if, God forbid, we have another situation like COVID that would affect your business and your commercial lease. So the first thing that I want all the tenants to be aware of is can you afford your rent? Be realistic, go through your business plan. This is something that you should take into consideration. Yes, now is a time to negotiate with your landlord, but usually commercial leases are signed for a term that is between 5 to 20 or even 30 years. So you do want to think of the future and be sure that you'll be able to pay the rent so that you're not in default now and in the future. Another thing to be aware of is your personal guarantee, and any sort of timelines with that. We'll get to that later on. And the next thing that I've been telling my clients to be aware of is introducing what we call a force majeure clause into your lease. This is not a standard clause that is found in leases. And it is basically something that protects all parties involved in the event of a catastrophe, or what we call an act of God. Usually these are natural disasters, a hurricane, a fire, but recently we've been seeing that both landlords and tenants have been including pandemics, epidemics, and government shutdowns as part of the force majeure clause. A few things to note regarding this clause: it basically forgives both parties from their responsibilities during this act of God. So let's say you had this clause in your lease, it included language that pertains to COVID and the government shutdown. The landlord would not have to be responsible for certain things during this time, and the tenant would not have to be responsible for their responsibilities under the lease, and that neither party would be in default if they do not act. The one thing to be aware of is that usually these clauses do not include non-payment of rent. So this is a huge thing. Obviously businesses are financially in a difficult position today, as they have been for the last 7 months, and we're not really sure how long this is going to proceed. So, force majeure cannot protect you in that sense, but tenants should also be aware of any other clauses in their lease, such as the guarantee, that would potentially allow them to get out of their lease with a minimal payment due or a minimal default. Also, the force majeure clause is defined very specifically by judges in the event that you do end up in court. And like I said, it does not include anything that would entail COVID. Although COVID seems like a natural disaster, in fact, the consequences to that are actually the government shutdown and the inability for people to be working or conduct business, which is not usually included in our definition of the act of God. And that is exactly why we've been recommending this inclusion in new leases. Some tenants might have this in their current leases, but again, COVID is probably not covered under that clause. The next thing we're going to talk about is tenants who are currently in a lease and are having difficulty making payments for rent, haven't been open for business, and are trying to figure out, what they can do during this time so that they can either get out of their lease, or they can maintain their lease without being in default, so that eventually when they could open, they have something to work with. So we've been seeing a lot of more communication between the landlords and the tenants during this time. That's important because unfortunately everyone's losing during COVID. Tenants can't conduct business, they're not making money. Landlords still have to pay their mortgage. They still have to pay, if utilities are being used, and various other fees related to owning the premises. And so their landlords and tenants are trying to work together to reach a mutual consensus that will work for both parties. No one wants an empty space, and tenants want some sort of security because you don't know what's going to happen in the future. A few things that we've been seeing regarding current leases is either a decrease in the rent, which is incredibly amazing, and I usually only see with smaller tenants like mom and pop shops, where the landlord might only own a few small spaces. They're more willing to work with their tenants, maybe because they have no other options or because they only have a few tenants to work with. This would mean that you agree to amend your current lease and say that instead of your rent being $10,000 for the remainder of the term or for the next year or so, you're going to reduce the rent to $6,000, $7,000, whatever is agreed upon between the landlord and the tenant. That's ideal. The second thing that we're seeing is either a reduction in the rent, but also an income-based payment to the landlord. And what that means is the landlord would take a portion of the tenant's income as a part of the rent. So even if the landlord agrees to reduce your rent by that $5,000 or so, they will take, let's say, 10%, 20% of whatever income that's coming into the business. That way, if the tenant is having a good month in a particular time period, then the landlord at least gets payment for any loss that they've incurred in the past. We've also been seeing tenants who are signing shorter leases. Usually, as I mentioned, usually leases vary between 5 to 30 years. That's because it gives each of the parties stability. A landlord wants to know that this tenant is going to remain in the premises. They'll be able to pay their rent. They want to be in this space. And a tenant knows that they don't have to move. They don't have to pay any sort of fees again, to go elsewhere. Recently, because of the instability of what's going on, tenants have been more willing to sign shorter leases, and landlords have actually been more willing to grant them. If the landlord sees that a tenant is interested in signing a lease, period, they're willing to sign a lease that's even for a year and then renegotiate after the end of the term. That's really important because it keeps the communication open between the landlord and the tenant, and it shows good faith on both parties because they want to remain in relationship with each other and maintain their lease. The last thing that we're seeing is a deferment of the rent. What this would mean is that a landlord would agree to a period of time where the tenant defers payment. So let's say from now until January 1st, the tenant does not have to pay rent, whatever that current rent is, but they would agree that in 6 months from now or 1 year from now, those few months, so it would be October, November, December, the 3 months would then be distributed in the repayment period. So for example, I'm a tenant, my lease is for another 2 years. I haven't paid rent, but my landlord is agreeing to do a deferment plan where I don't pay rent for the next 3 months until January, and then the repayment period would be June of 2021 until January of 2022. So I would have those 6 or 7 months to repay the 3 months that I'm deferring and any past payments due. That's really important because it gives the tenant a little bit of leeway to get back on their feet, remain in the premises, and still be able to make the payments later. Something that I've personally been trying to include in these amendments to the lease, especially for deferment plans, is the right to renegotiate the deferment. And that's important because we just don't know how long this is going to persist. And even if COVID does end and we could see each other in person, no one knows how long the effects on businesses are going to last. So, we know restaurants have been hit really hard. We don't know when the restaurants are going to be able to afford their regular rent for that repayment period, and then also pay the additional deferred payment of rent during the repayment period. So I try to see if landlords are willing to, at the time of the repayment period, renegotiate if necessary.
So just to jump in here, and I'm sorry to interrupt you, Nataly. As Nataly was speaking about this topic, I literally just fielded an email from a not-for-profit that, dried up once COVID, hit us, and they've just started discussing with the landlord about not being able to pay rent. They haven't paid since March, and how they're going to need to figure out a plan for what to do. And they've asked me to reach out to the landlord and try to negotiate a surrender for them, where at least they won't be chased by the outstanding debt once they vacate the premises. So I don't know if you wanted to just touch on that a little bit too.
Yeah, so a surrender agreement would be in the event that the landlord allows you to just leave the premises, and you would agree to a certain amount, due to the landlord, whether it's the entire rent that was due or something just to put the landlord back in a safe position. The tenant would have to remove everything from the premises the way that it would be under their lease, whether you're required to take only your personal belongings, or also bring the premises back to the way that it was prior to the lease. This is something that could be negotiated. I have a tenant now who doesn't want to surrender, but it looks like might have to, because they're just not reaching an agreement with the landlord regarding a repayment period or deferment period. The other thing to consider is a guarantee. Usually tenants sign a personal guarantee on their lease. And although, the tenant would still be liable under the lease, sometimes a landlord will allow the tenant to practice their rights under the guarantee, make certain payments under the guarantee, and also surrender their rights to the premises. A few things that have been enacted during this time by New York City, the governor, have also been helping tenants who are in distress. The first thing is that personal guarantees have been suspended from March until today is actually the last day, unless it gets extended again. And what that means is a personal guarantee is generally made by the individual who is the tenant or owns the business that the tenant, that the lease is under. And the personal guarantor would be liable for any payments that were not made by the tenant or whatever the guarantee says. So for instance, a personal guarantee would usually say that if the tenant wants to surrender the lease, they would have to notify the landlord at a minimum of 90 days prior to their surrender date. So that means that you would have to notify your landlord, continue to pay those extra 3 months of rent, and then surrender at the surrender date would be 3 months, which would be 3 months out. So you're still liable for the rent, but it's a shorter period than being responsible for the entire term of your rent and the entire term of your lease, which could be another 10 years from now. So what we've seen is that this personal guarantee has been suspended from the time that COVID began. And what that means is that if a tenant does default during March of 2020 to September 2020, then the landlord cannot demand this guarantee from the individual as they usually would be. Another thing is that there is a suspension of evictions during this time as well. We've actually just seen an extension of this until January 1st of 2021. So just for your information, that's both for commercial and residential leases. So, the government has obviously seen that tenants are in distress, and they're trying to help New Yorkers in general by protecting them against any sort of liability that they would otherwise be under. Joe, do you have a question?
No, I did, but I'll wait till later on.
Okay.
Good catch, though. You're getting good at this.
Yeah, I'll answer any questions at the end, but I was going to pass it on to Joe just to speak about relationships with employees and how you should handle them at this time.
Thank you so much. So I'm Joe Nohavicka. I'm Taso's partner. I've been doing this for a while now, 26 years in law, but This is my second career. I'm actually 61, and I've been in business, as Taso told you before. Let me see if I can share some of my experiences with you. And I'm not saying this because I think I'm smarter than anybody. You know, I'm telling you, I've just been down a road that you all are going down. And, you know, I have seen the, you know, the pothole, I've seen the log in the middle of the road, and I've seen the edge. And I'm sharing with you right now because I tripped in the pothole and over the log and fell over the edge. And so I'm here, I survived, and maybe I can help you with some things. So you followed Taso's advice, and you followed Nataly's advice, what they've been talking to. So you have your business planned, it's solid. You have your office picked out, your furniture's picked out, business is good. You made all the right moves, now you gotta keep making the right moves. Because business is good, you wanna make it better. And so the first thing that pops into your head are employees. Maybe you started out with them, but usually it's you get things solidified first, and then you start onboarding your employees. And let me just tell you before I even get into the employer-employee relationship, you know, there are other options out there. You don't have to get an employee right away. They do have these staffing services that are a little more expensive than having an employee, but it saves you a lot of problems because they cover things that you wouldn't have to worry about too much normally. So it's a good way to start off, and something to keep in the back of your mind that business startups do use staffing services initially. It's not a bad thing. So interestingly, the topic that Taso has given to me is working with others, which I find kind of ironic. But I'm gonna discuss this. And it's not just working with others in the workplace, because we're really working with most of our employees remotely. But you know, basically the same rules apply, and you have to be even more careful when you're dealing with employees, and the employees are dealing with each other. There was this great 2014 article, Computers and Human Behavior, and they talked about how people are emboldened when they're online and everything, and so they write things or communicate things that they wouldn't normally do if they were face to face. So as employers, you have to be aware of that, and you have to, when you're onboarding your employees and when you're talking during staff meetings, you have to remind them that there are protocols and there's behavior that's not acceptable, that wouldn't be acceptable if you were face to face, and that should be the touchstone for everything that they do. Unfortunately, I cannot see anybody out there, and usually when we have these live, I get to see these creative and courageous people, and I get this vibe from them, how, you know, excited they are to be going into business. And it's a wonderful thing. It's so exhilarating. I almost envy you people who are going into business on your own right now. It's a very exciting time. And even though we have these problems that are existing, they're going to pass. And you know what? Your business is going to continue on. It's not a bad time to be starting a new business either for many of you. So one of the things about the remote, one of the other things I wanted to talk about was, you know, when you're set up for remote conferences with your staff and everything, you know, you have to respect their emotions about things. You know, if they choose to not have their video on, you can't force them to put their video on. They may not be comfortable with having their boss inside their house. You know, that's okay. That's, you know, once you start invalidating emotions with your rationale, you're putting a wedge between you and somebody who's taking care of your business on a day-to-day basis. So you have to be very aware of that, and, you know, and not invalidate emotions of anybody in your staff. And by the way, it's not such a bad rule to keep in general, even when you're outside. Invalidating emotions is the number one way to curry resentment, and resentment in a company can be very bad. We'll talk a little bit more about that later. So we're going to talk first about employee handbooks. You know, as I said, you made all the right moves. Don't start skimping now. If you're going to have employees, you got to have written policies, and it should be in the form of an employee handbook. Going onto Google, you're going to get something, and that's something. That's a little helpful, but oftentimes it gets you into even more trouble than having nothing at all. And I'm going to tell you right now, there is absolutely no general silver bullet handbook that you're going to get from anybody as a one size fits all. Every company is different. Every company has different problems, issues, setups, and they should all be addressed. In the handbook, and this is a customized handbook, the first thing you want to address is the working expectations for both the employer and the employee. And this should be written, it should be articulated in your handbook in plain English. If you are reading this thing and you need a lawyer to interpret it for you, throw the book out and start again. Everything should be in plain English so that everyone understands, whether that's your employee, whether that's the administrative law judge, or whether it's the federal district court judge in the Southern District of New York that's going over while you're in the middle of litigation. And I'm telling you right now, your employee handbook as an employer will be your best friend. It will be your best friend as an employee as well, because it explains everything and you cannot deviate from the written word if it's clear to everybody. It's only if it's ambiguous, only if it's unclear that it becomes a problem and you need a lawyer for it. So you have your working expectations, you have your policies of how, for example, how to treat each other, whether it's remotely or in person. And we're going to get more into the sexual harassment policies a little bit later, but generally policies in the workplace. If you require in your job, in your business, for everyone to be dressed a certain way, then you should make that clear. So at least the employee has an opportunity to say, no, well, I'm not wearing that. This is, I'm just not going to do this. All right, so they found out this is not someplace they want to be. They know at the outset. It's not a surprise to them, and then, people come in and they dress a certain way that's against your personal policy, and they're there for months. And then you say, you know what, I don't like this guy. And you call them in and you say, I don't like what you're wearing. It doesn't, you don't meet our profile. You're out, I mean, that's not fair. And, if you get it brought before that issue up before a judge or administrative law judge or arbitrator, they're going to agree with the employee. Next thing you want to talk about clearly is discipline. Like, what will happen? The employee has to be on notice. If they come in late 5 times during a certain working period, they're going to get a warning. After the first warning, they're going to get terminated, so that they can't go in when they're fired after missing 10 days that they didn't have notice of what the expectations were, what their obligations were. So it's got to be made very clear as to what the discipline is, what it means. All right, it's got to be spelled out. It can't say, you're going to be disciplined for cause. That's not enough. That doesn't mean anything. You will be if you strike another employee. I know this is very specific, but if you strike another employee, you're automatically terminated. Okay, clear. So somebody goes in and they're pushing them around and they do something like that, they're going to get fired. They knew that they were going to get fired when they did it. They did it anyway, and that's the end of it. And then finally, your employee handbook has to discuss protections from claims such as harassment, like I said, and for wrongful terminations. And that is just very clearly spelling out what they're required to do, what they're required not to do. All right. And this way, it's not a guessing game. So as I said, the employee handbook becomes your best friend especially if you're an employer, though, because you're usually the one defending a termination. And one of the problems that comes up is it's someone whose first language is not English. It's another one. All right, they were fine. They spoke English during the whole time that they worked with you. You didn't need an interpreter. They understood. They did their job fine. Now, all of a sudden, they're claiming they don't speak English well. And they come to you at the Unemployment Insurance Board for a hearing, and they have an interpreter. You're like, what is this? I'm going to tell you one thing. First of all, people whose second language is English, their command of that second language, that English as a second language, diminishes in proportion to the amount of stress that they're encountering. And court depositions, hearings are very stressful situations, and they forget everything. That's just the psychology of it. That's what happens. They're not trying to trick anybody. This is just a reality of how it works. Some are better than others, but if they're requesting an interpreter, that's the explanation. It's not because they're trying to trick you or they're trying to curry sympathy from the tribunal. So how do you resolve this? You had no clue as to whether or not they understood the employee handbook. Well, what you do is you insert a page in their first language that says that I have been given an opportunity to have an interpreter interpret everything, translate everything in this handbook. I understand that and I waive that in their language and in English language. So you can present both of them to the tribunal. All right. And that's how you defend yourself against that. That's one thing. And it's a really, really important thing to have. All right. So there's your employment handbook in a nutshell. And as I said, there's no one size fits all. You have to come into us or you come into your lawyer and you explain exactly what it is, how your company is set up, how you communicate with each other, and spell out everything from benefits to discipline to behavior and everything that's got to be there. It doesn't have to be a giant book, and make sure that it's in plain English. Okay, stay away from the legalese. It sounds really cool and stuff, but it's totally useless if no one understands it. Harassment policies. Our firm, we give seminars and we give instructions, counseling to managers who really don't understand the boundaries that are supposed to be in place. And I'm not smiling because I'm downplaying the importance of this. I'm smiling because of the stupidity of these people who are so educated in such high positions with such big power. They ask me and Taso, well, this is an actual quote. We're very affectionate at our firm. I mean, and I'm not going to even go into how else he was explaining their behavior. But I mean, really, that's you're very, anything that comes after we're very affectionate at the firm is going to end up in a bad place. All right, it's like, come on, smarten up. You're affectionate. This is a workplace. They're being affectionate to you because they work for you, not because they think you're the greatest person in the world, you moron. Yeah, you get it. You see our frustration with this? They need sensitivity training, and you have to have strict policies in your organization, so that when you're onboarding a manager, or it doesn't matter, from the highest to the lowest position, they all have to understand that you take this very seriously. You set the tone. The owner of the company sets the tone about how they treat harassment and discrimination in the workplace. You set the tone. And if you're the guy who sets the tone, or you're the woman who sets the tone, you say, we're very affectionate here. I mean, where does it go from there? That you don't understand that the need for this boundary, where an affectionate workplace is just inappropriate on its face. All right. So your policies have to be very clear. And this is something, especially if you're in New York alone, that is very, very strict. And there are a lot of little things that you have to be careful of. And you have to show proof that you actually explain these things of what's appropriate and what's not appropriate. A lot of it is common sense, you would think, but it's not. Okay, so everything has to be spelled out for them. And the harassment policy should also be included in your employee handbook. And that brings us to harassment training. As I said, we train managers but new employees should be trained as quickly as possible. We just had a new case in a store where one of the employees thought it was appropriate to pick up one of the cashiers and say, "Oh, you're so late." I mean, does that seem sane to anybody? I mean, you imagine, somebody who you care about, somebody from your family getting picked up by some idiot, in a shop. I mean, really, they think that that's okay. And you know what? It's not all his fault. Okay. They just don't know any better. It's really the fault of the employer for not explaining and setting the boundaries, and maybe even setting the tone of that everybody is to be respected here. No, you can't just pick people up. You can't touch them, and it's just not acceptable. It's, sexual harassment is, it's a crime against people, but it's also a crime against industry. It excludes a whole group from having a peaceful workplace. Think of that. It's a crime against industry. So your harassment training, which is required, by the way, now in New York, You have to have harassment training every year. And the person who's training, as we do, we give examples of what's appropriate, what's not appropriate. We give the, the picking up the employee example, and make sure that everybody understands. For employers, the important thing is that you have to keep records of your training, who was there, who did it, how long it took, okay? Because you're gonna get audited by the Department of Labor or the Equal Employment Opportunity Commission, and you're gonna be required to pull those documents. And you should keep those documents for no less than 5 years after the termination of that employee, because you, as I said, you might get audited. As a matter of fact, I recommend, and Taso recommends, 6 years of keeping them. All right. Tas, I'm sorry. Okay.
We also perform that training very often in other languages as well, which I think is something that's very important for a lot of you.
Yeah, absolutely, because then they have the same defense available in the that I gave as an example with the employment handbooks, the employer handbooks, employee handbooks, that they say, well, I just didn't understand it. I think it's very helpful to have that translated document saying, that acknowledgement saying that they were given an opportunity to have it translated, and they decided that they understood okay. And this is where that's very strong proof. Let's talk about contracts, okay? It's a little less, antagonizing, I think. Because I even get upset by this, by seeing what people do to perfectly good businesses, perfectly good, and they have one person who doesn't understand discrimination and what it is, and thinks that they can be flip about, they have no understanding about microaggressions or, offending people, using subtext. Anyway, that's for training. Those are things that we take care of. Make sure the people that you onboard are inoculated against that, okay? And that they understand that it is unacceptable. Employment contracts. Your employment contracts, I'm going to be brief on this because it's a little dry, but your employment contracts should not be taken off Google. That's a sure way to end up in trouble. It's very cheap, but you made all these right moves. As I said before, you had your solid business plan, you have your lease, you spoke to Taso, you spoke to Nataly. Now you're going to blow it on a contract, and you're going to go to Google and download and hopefully you're just going to hope that that's going to hold up in court. Bad move. Compensations, benefits, termination, everything should be spelled out in the contract, okay? Same warning with the language if English is a second language, okay? Just make sure they have it in there. And you're not going to be violating any laws by saying, like, here's the contract. Would you be more comfortable having it in another language? Would you understand it better? That's not discriminatory at all, all right? You can ask that. You're trying to accommodate them and make sure that they understand everything. All right. Non-disclosure agreements for you entrepreneurs out there that have more ideas, and now you're going to share them with other companies, all right? You must have a solid non-disclosure agreement that's in compliance and under the protection of New York state law, which is different from other states. I mean, generally, it's that you see some common things, but if you pull off a non-disclosure agreement off of Google and you look at one of ours, here in New York State, you're going to see differences, important ones. Hopefully that won't be too late, okay? Non-competes for your employees. This is important too. You have people that are working for you, all right? And while you're paying them from 9 to 5, they are starting up with an outside partner, a company just like yours, using your models, your pricing models, like, for example, we had one with the pesticide company, and they were taking their mixtures of chemicals and to save money and still get effect. These are all things that are protected. So they're out there and they're starting their own company while you're paying them. Two things. Number one, it's illegal to do that. There's a doctrine called the faithless servant doctrine, which means that you have a duty of loyalty while you're working with your employer. If you do something on the outside, like the model that I just gave to you, they can grab and they can force you to disgorge every penny that they paid you from the moment that you started with this faithless servant behavior. So you risk losing everything, all right? Anyway, this non-compete agreement lays it out clearly what the employee can't do, all right? This way they can't say, I didn't know. We wouldn't do anything to hurt, to hurt that company. They were good to us. And finally, independent contractor agreements. For those of you, it's kind of strange to have that here because we're assuming that you're getting employees too. But just remember, the commercial law, in commercial law, actions speak louder than words. Okay, plain, simple, non-legalese. Actions speak louder than words. It doesn't matter if you say that you are an independent contractor or that person is an independent contractor and they signed and they agreed and they notarized it and acknowledged it. It doesn't matter. It's how they behave, how they're treated in the workplace. That's what determines whether you're an independent contractor or not. Don't screw it up. Just getting down to the final points, as far as documenting everything. Business is taking off. You're getting new clients. You're getting more business. Don't start getting lazy with your documentation. You must document everything with respect to day-to-day activities, with respect to how you're protecting your intellectual property, how it's being used, how it's being put out there in the public. These are all very important things. Document everything. Okay, this alone is like a 3-day seminar, just this topic alone, and I can go on, but I'm going to stop right here. I hope it's been helpful, and if you have any questions, I will be available, as well as everybody else on the panel. And now I'd like to introduce you to Gianna McArthur.
Hello, everyone. The next section of the webinar will be a discussion about protecting your intellectual property. I want to thank you all for remaining, and I hope you can find something that you can use. So I'll first start out with trademarks. Trademarks are symbols, a variation of fonts or words, which are used to identify your specific good or services. Now, trademark rights are acquired through use, in commerce, so you have to continuously use your mark so that consumers are able to identify your goods and also to distinguish your goods from other goods. So that's important. Now, the trademark process can be lengthy, and it does require continuous communication with the USPTO, and you have to respond to a lot of their requests for information. So when you are considering to register for a trademark, you may want to start ahead of time just gathering certain documents. For example, you might want to keep a record of when you first started using your mark in commerce. It's important that you have a timestamp just so you can show the date of when you were using this mark in commerce. If you were using the mark in connection with a website, you would want to include your URL as well. So it's just important to be prepared if it's something that you're considering later on. Again, during the application process, you would have to identify a specific classes where you intend on using your mark. So let's say, for example, you want to use your mark on clothing. You would have to include that in the actual trademark registration, and you also would want to include the specific items of clothing where you will use your mark. It's important to think about where you plan on using your mark ahead of time, because your registration will only be good for the classes included in the application. So just keep that in mind. Also, trademark use is continuous. So even after you receive the official registration with the USPTO, if you fail to continue to use the mark in commerce in connection with your specific good or service, there is a potential that you could potentially lose your mark. So it's just important to continue to use your mark if you do intend on keeping it. Now, registering the trademark registration gives you a lot of enhanced rights. For one right is you have the ability to prevent others from using your mark on a similar good in commerce. Also, once you have a registered mark, you can prevent others from using a similar mark getting a registration for a similar mark, which has the potential to confuse the origin of the source. So once you have the mark, you do have exclusive rights to the marks for the classes that you identify in the registration. Once you receive a trademark registration, your registration appears on the official USPTO database. So everyone is on notice of your exclusive ownership of the mark. Also, once you do have the trademark registration, you do have exclusive rights. So let's just say you find out that there is another user that uses your mark or a similar mark in a similar class. You would have the ability to send them a cease and desist letter, just demanding that they stop using your registered mark. You can also sue them for damages. And also you can get a court injunction, which would force them to stop using your mark. Copyrights are another form of intellectual property. Copyright registration prevents original works of authorship. Usually you would get these for songs, plays, dances, things like that. Copyright protection applies to both published and unpublished work, but when you do have the official registration, you have the opportunity to exclusively reproduce the work, sell the work, and display the work publicly. So a copyright registration is important to you and to protecting this form of intellectual property. Now, patents are another form of intellectual property. It's more of a property right for a new, useful, or non-obvious invention that you come up with. When you are considering to apply for a patent, it's important that you work with a patent attorney early on. There are certain requirements to filing for a patent, so it's important that you meet all the requirements. One of the most important requirements is the time period. You'd have a limited amount of time to when you can file for a patent. So you should, if you're thinking of filing for a patent, you should contact a patent attorney as soon as possible. So with with the trademark registration, the copyright registration, or the patent, you do have the ability to prevent the infringing goods from entering the United States. So with the official registration, you can work with the Customs and Border Patrol Agency. And if you find out that there is a shipment of infringing goods, you could have them detain, destroy, and seize the goods. And this would be beneficial for you because this would reduce the amount of competing goods on the market. Also, if the infringing goods are of a lower quality, this would prevent consumers from confusing your quality good with a lower quality good and preventing consumers from making a mistake in confusing your mark with these poorly made goods. So that was just a brief overview of protecting your intellectual property. And now we will get into the question and answer portion of the webinar. And I want to thank you all for remaining with us.
Thank you, Gianna.
Thanks, Gianna. So let's see. Okay, Rick White. Question regarding the posting of a business's COVID plan on site. When we reopened, we had to upload certain documents to the state website. We will not be starting up indoor dining. Do we still need to post a plan on site? Answer, yes. The plan is not just if you're not reopening indoor dining, and it's not just for your customers, it's for your employees as well. So the plan must be available in case the Department of Health decides to inspect your business, and it is mainly geared for your employees as well as your customers. Okay, so it must be on site. So print it and post it. Okay. Question: would negotiating a one-year lease to be in effect during the crisis run concurrently with a lease already in effect, or take the place of a current lease for that period of time? Natalie, would you like to answer?
Sure. So I think I understand your question, but I'm not sure if you mean you want to negotiate a new lease or amending the current lease, but that might answer your question. So there are two ways of doing this. You could either take what your current lease says and amend it to either extend it for an additional year or shorten it to a year. Amending the lease could basically mean anything, even if it's rent changes or different terms of the lease. If you're negotiating a new lease, then there might be still an amendment to the old lease or some sort of termination to the old lease. So, you know, my answer would actually be you're most likely drafting an amendment. It should be in some sort of document and should be signed by both the landlord and the tenant.
And just to add to that, you cannot have two concurrently running leases between the same two parties for the same premises. So Natalie's answer on the amendment is correct. Okay. Let's see. I thought that Governor Cuomo had extended the moratorium on evictions and personal guarantees through the end of the year. Wasn't that announced last week?
So I know that the eviction moratorium is until January 1st, 2021. I know that they want or had talks of extending the personal guarantee suspension, but I'm not sure if that was extended any further.
It has not been to our knowledge, but they are discussing it now.
I believe it terminates today. Today's the last day. Yeah. And then I think he has one more question for me.
You guys know my landlord. I have a great relationship with her. We began a 2-month closure on April 1st, and we renegotiated a 30% rent reduction. I didn't leave the house much during those 2 months, and we did not sign anything. I probably know the answer, but under my particular circumstances, do you think I should have some sort of memo signed?
Yes.
There you go.
Anything that is agreed upon, especially if you have, first of all, in New York and in general, everything has to be written down, signed by both parties. Your current lease, I could tell you 99%, has 2 clauses in it. One that says any sort of changes to the lease must be signed by both parties. And 2, if the landlord accepts any sort of check that is different from the amount that your current rent is, then it doesn't necessarily mean that the landlord is accepting that rent as the full amount. So what that means is that if you haven't been paying since April, May, June, July, August, September, you have 6 months of the difference that your landlord could potentially come after you for. So definitely get that in writing. It doesn't necessarily have to be something complicated, but I would recommend reaching out to the landlord saying, please write something. You can review it yourself, send it to me to review, but yes.
Awesome. Even if the memo specifically says renegotiated rent.
What do you mean?
It's a follow-up to what we were just discussing. So he's saying even if the memo says renegotiated rent, you mean the memo on the check? On the check, yes.
Oh,
Even if it says that, even if it says
yeah.
that's not a contract.
I had an issue one time. This is related but different. The tenant was paying rent from a account that had a different name from whatever the tenant was on the lease. Also not allowed, not acceptable, even though the memo said, for XY restaurant. You want it memorialized in a document that is signed by both parties just to protect yourselves. So yes.
Thanks, Natalie. Susan, do you have copyright, patent, and trademark attorneys currently in your office at Manhattan's locations? Yes, I am here right now. So yes, we do. I hope, Susan, if you have any questions, you can call or contact, okay? I'll leave you guys my numbers here, and I'll even leave you my cell phone number so you can reach me anytime, okay? Thank you guys for the comments. Thank you, Irene. Thank you, Edwina. Does anybody else have any questions or any comments before we go? Guests, panelists? Going once? Thank you, Rick. Going
Thank you.
twice. This wasn't as heated as the debate last night. All right, guys. Well, hi, Maria. Have a great day. Have a great rest of the week. And hopefully we'll do this live soon.
Thank you all for joining us.
I'm signing off.
Goodbye.
Bye.